On Friday, June 14th, the Karen Reed trial continued with day 25 of testimony. On this day, there was a little bit of drama to start out the day related to jurors, or at the very least one juror. And as a result, one juror was dismissed and Judge Cannone took away the media's privileges to broadcast the courtroom for most of the morning. Anyway, aside from that, this was a very important day in forensics, particularly for the prosecution. And so the jury heard from two witnesses. The first was Jessica Hyde, who testified as an expert about an in-depth digital forensic analysis about Jennifer McCabe's Google search for how long to die in the cold on the morning of January 29th, 2022. And the second witness was Trooper Joseph Paul of the Massachusetts State Police. He testified about an accident reconstruction analysis that he did to analyze how Karen Reed's SUV would have hit John O'Keefe, according to the prosecution. Overall, I would say that Ms. Hyde's testimony was actually very strong for the prosecution. However, I cannot say the same thing about Trooper Paul's accident reconstruction testimony. So what does that mean in the greater context of this trial? Watch the video until the end so I can explain my thoughts. And in the end, tell me what you think. This is a long recap, but for a good reason. So buckle up and let's get into it. Okay, so let's start off really quick with what happened in the morning. The details of the origin of the situation don't seem to be publicly available, so it's unclear exactly what triggered everything. But what we do know is that at the beginning of the day, 3 or 4 jurors apparently were called up to see Judge Cannone at sidebar to talk to her about something. And long story short, as one of the female jurors was getting escorted by the bailiffs to talk to Judge Cannone, apparently she was caught on camera by the in-courtroom camera operator. And so there is footage out there where you can see her walking by. I came across this footage myself, but I am not going to show it here because we don't need to amplify this massive mistake even more. Obviously, if you've been following this channel for a long time, you know that jurors are never supposed to be captured either in photos or videos inside the courtroom. And the media typically does take this very, very seriously. Their identities are supposed to remain shielded throughout the trial, even though, yes, anyone in the general public can go in and see them themselves. And the reason for this is the amplifying power of photos and videos, especially when combined with the virality of the internet, can create some serious problems for the jurors and for the judicial system as a whole. We do not need the internet running around to figure out who these individuals are and then trying to find some way to find them and perhaps interfere in the trial. Anyway, Judge Cannone was upset about the disclosure of the juror's identity, and that part is obviously understandable. And as a result of this whole thing happening, she told the media that she was revoking the broadcasting access to the courtroom for the morning, essentially as a punishment. However, and don't get me wrong, I will often speak out against all kinds of issues that I see with the media, particularly with their reporting on trials, things like that. But I don't think that the responsibility here is squarely on the media. The juror who appeared on camera was being escorted by the bailiffs through the main entrance of the courtroom, not the usual door that the jurors use to go in and out of it. And the placement of the courtroom camera throughout this trial has obviously been intended to expressly avoid any chance of showing the jurors either while they're seated during the trial or when they're entering or leaving the courtroom. So if they had continued to use that side door that the jurors have been using, this wouldn't have happened. And if what I've heard is to be believed, the bailiffs apparently didn't give the camera operator a warning that they were coming through these main doors in advance. So to me, Judge Cannone reprimanding the media does feel somewhat misplaced. If I am wrong about that last part, that the camera operator did in fact have enough warning about this and that they were just being lazy or something, then I will take that back. But otherwise, the judge really is responsible for orchestrating the courtroom, and if the bailiffs are changing the procedure on everyone and not letting people know in advance, they also share blame. Anyway, after all of this, like I said, Judge Cannone ended up dismissing the juror before proceeding with testimony. There's no indication as to whether the dismissal is connected to the disclosure or maybe whatever it was that was the underlying topic about which that she was talking with Judge Cannone in the first place. But either way, the judge instructed the jury not to worry about it and basically said that the juror had been dismissed for reasons that were personal to the juror. So now there are apparently 9 women and 6 men on the jury for a total of 15. And in the end, 12 of those 15 will end up seated and deciding the verdict in this case. Okay, so on to the first witness of the day. This was the Commonwealth's 63rd witness, Jessica Hyde. Miss Hyde is a digital forensics examiner, and she owns the firm named Exordia. And she was there, like I said before, to testify about Jennifer McCabe's Google search, "Hoss long to die in cold," or "How long to die in cold." And let me just say, throughout this trial, I have been giving my candid opinions on either side. And I'm going to continue doing that to include my commentary on this witness. Now, overwhelmingly, I've been giving positive commentary for the defense and negative commentary for the prosecution. And a big reason for that is because it seems like every single witness brought up by the prosecution has had, at best, a mildly positive impact on the prosecution's case in chief. But more often than not, it seems that the vast majority of these witnesses have actually been pretty favorable to the defense, if anyone. That is, except for Miss Hyde. Now, people who are pro Karen Read, and especially the ones who are convinced of the defense's theory about a conspiracy to frame Karen Read, may not like what I'm going to say about this witness. But I think that she was unequivocally good for the prosecution's case in chief. And personally, with Miss Hyde's explanations about the digital forensics on this specific issue, I'm now actually pretty convinced that Jennifer McCabe probably did not, in fact, Google "Hoss long to die in cold" at 2:27 a.m. on January 29th, 2022. Let me explain why, and then I'll get into what this means for the trial overall. However, before I get into what Miss Hyde testified to and my further thoughts on it, let me first acknowledge a huge asterisk for her testimony. See, I had the luxury of watching her testimony on replay on YouTube, and so I was able to go back and listen to what she said multiple times so that I could ensure that I understood what she was saying, at least to a sufficient level. But this was incredibly technical testimony. I do think that she's really great at explaining things, generally speaking, and she clearly has a lot of enthusiasm and passion for her work that comes across well as an expert witness. But she does have a tendency to give long-winded answers in order to give very full answers. And this is really great for getting a complete view. But if you find yourself lost at some point midway in any one of her answers, you might get completely derailed in being able to follow along with her. And this is really not helped by Lally's long-winded, unclear, disorganized questions on direct examination. I'm sorry, I thought this witness was great for the prosecution, but I still think that Lally has a lot to improve upon with his direct examination style. But anyway, how much all of this the jury was able to actually absorb without the benefit of replay like what I had is unclear to me. I can say that personally, if I didn't have the ability to pause and go back over her answers and explanations, I very well could have ended up lost myself. But because I did have the benefit of pausing and rewinding, let's go over her testimony. Basically, she did an in-depth analysis of the Google search for "Hoss long to die in cold" as it was extracted in the Cellebrite report. And she did this in multiple ways, which I'm going to try to simplify a bit so that we can hopefully not get too lost in the weeds. I recognize this is still a long video, so bear with me. Also, typically for this part of the recap, I would use all the charts that they show in the courtroom as B-roll visuals to make it easier to follow along with what I'm saying. But unfortunately, during her testimony, we were working with the court's own Zoom version of the court proceedings because remember, the broadcast privileges were taken away, as opposed to the normal camera operations that we've gotten used to. So the audio and visual footage were both pretty terrible during her testimony. And when they show the exhibits on the screen, they couldn't show up for us watching on stream. So really all that we have in terms of visuals from this testimony is what we've seen before from the Cellebrite report, which we thankfully actually saw during Jennifer McCabe's cross-examination. So all visuals that I'll use here are going to be the ones from Jen's cross-examination. So here are the Google searches that are timestamped in the Cellebrite report that were noted for 6:23 a.m. and 6:24 a.m. on January 29th, 2022. And here is the 2:27 a.m. entry from Cellebrite. And here's where you can see a little more detail in this chart with all of them together. So when we're looking at these entries in the Cellebrite report, we have to become familiar with what exactly these different entries mean. And apparently, although we have not yet heard from the defense expert, apparently what he says is that this 2:27 a.m. entry means that at 2:27 a.m., Jen McCabe searched "Hoss long to die in cold." If this is in fact correct, this is obviously super sus because it's long before John O'Keefe was found in the cold. And so it then looks like at 6:23 a.m., Jen searches again at perhaps a less suspicious time when Karen is freaking out about John's status as he's being worked on by the paramedics and basically losing her mind. And so it looks like she tried to get the exact match at 6:23 a.m., but then saw that it wasn't exactly the same as the 2:27 a.m. search. So she then tried again at 6:24, this time matching it up exactly to the 2:27 a.m. search. And looking back at the Cellebrite report, it also looks like the 2:27 a.m. entry was deleted. And so that's how all of this looks. Admittedly, that does require some pretty in-depth knowledge of tech by Jen McCabe to be able to delete a Google search like that and try to line up those searches to exactly match it. But her husband, Matthew McCabe, testified that he does work in tech, so maybe there's some knowledge that she's absorbed around the dinner table. But even still, I always want to know, what's the prosecution's explanation for this? Is it good enough to explain this sufficiently and set the theory, at least as to this particular Google search, to rest? And the reason why we're asking for the prosecution's explanation is because they're the ones with the burden of proof here. At the end of the day, we're asking whether or not the prosecution has put on a good enough case. And as to this particular subject, like I already mentioned, I think it's a reasonable and convincing explanation. So to start out, Ms. Hyde explained that she used a handful of software analytical tools to get to the bottom of this question over the Google searches. There's Cellebrite, there's SQLite, there's a bunch of these tools. And this is because different tools will show you different things and will give you different depths of analysis. And when she used these different tools to extract the 2:27 a.m. entry, she said that not all of her tools picked it up. Cellebrite was one of the few that did. And that's how it showed up here on this particular chart that we saw in Jen McCabe's testimony. More specifically, it says in the Cellebrite report that the source of the 2:27 a.m. entry is an artifact called browser state DB wall. Before we get into what the 2:27 a.m. timestamp means as it relates to Haas long to die in cold, we have to get a foundational understanding of some of the broader pieces at play here. So to do that, let's start with the source of this 2:27 a.m. entry in the Cellebrite report. In other words, where was this data found on this device? And like I said, the source of this entry is browser state DB wall, or browser state DB. And at the end of the day, DB stands for database. Ms. Hyde described this as a very intricate artifact, meaning it required a lot of digging to fully understand what's going on here. And so what is browser state DB? First of all, like I said, it's something called an artifact. According to Ms. Hyde, an artifact is any trace left behind by any action on a digital piece of data. Based on my new understanding of this, I'm kind of thinking of it as like footprints in the dirt after someone's walked by. So an artifact is kind of like a digital footprint that can show up in different ways. Ms. Hyde said that artifacts will be details like time, date, and recipient of a text message as it shows up in a database on the device. More specifically, according to Ms. Hyde, browser state DB is an artifact that is also a type of write-ahead log or wall, spelled W-A-L. So what is a wall? A write-ahead log. The way I understand it from this testimony, in a nutshell, it's a temporary space for data. Ms. Hyde said that the way that some of these databases work, they first get pulled into a temporary space before they get committed to a permanent space on the device. She compared the permanent space to basically an Excel file where you have all the data mapped up into specific boxes. And she said that the temporary space is more like a text file where all the changes that need to be done are written out and basically word vomit on a single white space. The way that I understand it and kind of conceptualize it, I kind of think of it as like a whiteboard for my ADHD thoughts and reminders before I organize them into a formalized to-do list. For example, a thought comes up when I'm in the middle of some other task here and I jot it down somewhere on the whiteboard that I have over here so that I don't instantly forget it before turning back to the task at hand. Then when it's time to actually put together a to-do list, I'll look at the whiteboard and it helps me remember what I actually need to get done. And then once I've made the list, I erase those things from the whiteboard. I'll do this for things like task reminders, for things that I need to put onto a calendar, or ideas I have for content, or pieces of explanations or arguments that might not be fully fleshed out yet. Similarly, a wall or a write-ahead log basically groups commands from a bunch of different functionalities together into this pooled space until those commands get committed to their permanent space. These different things can include Google searches, deleting text, opening a tab, closing a tab, etc. And so this log basically lists any changes that you made on your device while that app was open until you close the app. When you do close the app, those commands get committed and they disappear from the wall and show up in the appropriate database. So because of that, a wall usually doesn't get kept permanently. This also now explains to me I think, anyway, why having so many browser tabs open on my computer and phone all the time has given me the perpetual problem of my devices slowing down. Anyway, so if a WAL file is something that is not typically kept on a device, what is Ms. Hyde's explanation for it showing up here in the Cellebrite report? Well, she said that the only reason why this would show up in a Cellebrite report is because when Jen handed over her phone for the extraction, she didn't close out the Safari app. So because of that, it hadn't yet been committed to a permanent database and erased from the wall. Given the fact that Jen did hand over her phone for the extraction on like January 29th or January 30th, right after the incident, I can see this as actually a reasonable explanation. Okay, so next let's talk about what this 2:27 a.m. entry actually means according to Ms. Hyde. As a reminder, the defense expert says that this means Jen McCabe Googled Haas Long to die in cold at 2:27 a.m. And looking at it at face value, it kind of looks reasonable, to me anyway. But what does Ms. Hyde say it means, and what's the basis for that opinion? Bottom line up front, she says that the 2:27 a.m. entry does not indicate that Jen made that Google search at 2:27 a.m. Rather, she says the 2:27 a.m. entry indicates what time Jen McCabe opened the tab that the search appeared in. Not gonna lie, when I first heard that, I was like, well, how in the world does she reach that conclusion? But basically, here's how. So remember that I said that according to Ms. Hyde, browser state DB is a type of write-ahead log or wall. Well, Ms. Hyde testified also that browser state DB is a type of wall that is specifically dedicated to when tabs are moved. This means opening, closing, or switching tabs, or even minimizing the app so that you can open up another app. So looking back at this Cellebrite report, she's essentially saying that because the source of this entry is browser state DB, this timestamp only has anything to do with the function of the tabs in Safari, not the search in Safari. Timestamps in the chart that relate to browser searches will be found in some other kind of a source like knowledge CDB or plist, not browser state DB. I really hope that makes sense because that is actually a very important detail. Okay, so I followed that Ms. Hyde said that browser state DB only has to do with movements of the tab. So why was she so confident that 2:27 a.m. was specifically when the tab was opened? To be clear, she said that she didn't know for sure what kind of tab movement happened at 2:27 a.m., but she said that she knows for a fact that it had to be a tab movement. But she did say that there was a high degree of likelihood that it was opened at the time because she found a different entry elsewhere from a different type of artifact that indicated at 2:27 a.m. Jen Google searched for the Hawk Mock sports website or something. Remember that Jen testified that this was her daughter's hockey league or something like that, and she said that she was searching around 2:30 in the morning. And so this does appear to corroborate that specific part of Jen's testimony. Ms. Hyde says that this initial search at 2:27 a.m. lines up with the tab also being specifically created at 2:27 a.m. Anyway, so then of course the next question is, if the 2:27 a.m. entry means something about the tab movement and not the search, why in the heck is the value box on this particular entry saying Haas Long to die in cold? Why would it say that in this box if Jen McCabe didn't search that until like 4 hours later? Well, according to Ms. Hyde, for an entry like this that is sourced from browser state DB, that value box is something that can get updated again and again and again while that app is open. More specifically, she said that it will always be populated by the most recent search made in that tab. So remember how I said that the defense theory was that Jen made these later searches to try to match up with the 2:27 a.m. search to essentially cover it up. And when that came up in Jen's testimony, I remember thinking, yeah, that looks super sus. But if this is how Cellebrite entries like this always work, that the value box for a browser state DB entry always shows the latest search that was made, that actually rebuts the defense theory on what they say that Jen was doing. And I have to say, it rebuts it with very simple precision. And that would mean that this doesn't in fact show that a search was made at 2:27 a.m. for Haas Long to die in the cold. So this whole entry requires a lot of super technical explanation, obviously, but once we get there, it actually makes a lot of sense. Okay, so then if the 2:27 a.m. Cellebrite entry doesn't show when Haas Long to die in cold was Google searched, how do we find out when it was searched? According to Ms. Hyde, you can't find that information using the browser state DB artifact. Instead, you look for artifacts like those called knowledge CDB or plist. And sure enough, those Cellebrite entries for 6:23 a.m. and 6:24 a.m., which show how long TI die in CLKD and then Haas Long to die in cold, are both sourced from either knowledge CDB or plist. But how does Miss Hyde say with confidence that these were the first times that Jen made these Google searches? Well, Miss Hyde says that this is informed by the fact that at 6:22:49 a.m., there's an entry in the cache DB that basically says that Google suggested the search for Jen, how long to digest food. The data shows that she rejected that suggestion and at 6:23 a.m. and 6:24 a.m. made the searches. So the fact that this was first suggested at this particular time and then rejected by Jen McCabe is an indication to Miss Hyde that 6:23 and 6:24 were the earliest searches for this kind of information. Now, on cross-examination, David Yannetti tried to wiggle in some uncertainty about Miss Hyde's conclusions. Specifically, he tried to get Miss Hyde to say that she really can't rule out the possibility that the user of the phone conducted the Google search in question at or before 2:27 a.m. And her response was basically, look, there's a very unlikely possibility that that could happen, but it's incredibly unlikely because there's simply no evidence in the data that the search occurred at or before 2:27 a.m. So in other words, that possibility would be based on thin air. So I have to say, this was the first time in this entire trial that I personally think the defense's cross-examination was totally ineffective. And it's not because Yannetti somehow did a bad job or he's somehow a bad attorney. Yannetti is an incredible attorney who does some very skilled cross-examinations, as we've seen time and time again in this trial. Rather, it's because the facts on the side of the prosecution on this specific issue are, in my opinion, stronger. Okay, so what does this mean in the grander scope of this trial? If you're dead set on the prosecution's theory that Karen was framed, this could have an impact on the strength of that theory. There still have been a lot of pieces to that theory, particularly when we're talking about the activities of a lot of different people involved here, including Trooper Proctor. But if your belief in that theory relies on this particular search being what the defense says it is, then I think that it really weakens it. But as I've said many, many times in this trial, the defense does not need to prove that theory to secure an acquittal. For the defense, it's simply a nice to have if the jury adopts the theory, even if it's just most of the theory. But it's really not necessary to win. Remember, the Commonwealth here has the entire burden of proof in this case. And the Commonwealth has to prove to the jury beyond reasonable doubt that Karen Reed murdered John O'Keefe in the early hours of January 29th, 2022. The question of whether Jen McCabe made that Google search at 2:27 a.m. is them having some success on defense in the context of the defense's theory. It doesn't actually move the ball forward for when the prosecution needs it most in their own case in chief. More specifically, it does not impact whether the prosecution has proven to the jury that Karen actually murdered John. And at this point in the trial, 25 days in, the prosecution is cutting it dangerously close to the end of their case in chief before they make that showing. In my opinion, the prosecution at this point still has not met its burden. In fact, they haven't even given the jury an explanation of how Karen specifically murdered John, other than the argument that the murder weapon was the passenger taillight area of her SUV. They simply haven't done enough to convince me at this point in the trial that Karen Reed should be convicted of murder. But okay, the next witness's testimony finally speaks to the potential causation of John's death. So let's turn to him really quickly. So the next witness was Trooper Joseph Paul of the Massachusetts State Police. And as I said before, he testified as an expert witness on accident reconstruction. So we really should be getting through him all of the details of how it was that the car caused those injuries and how it was that the impact even happened in the first place. And so his testimony took up really most of the day. And at the end of the day, his direct examination didn't even finish yet. So we'll really see how things look after his cross-examination. Hopefully that starts and ends on day 26. Anyway, he testified that he mapped out where John and the various pieces of evidence found around him landed and did some approximate measurements to figure out the distance between these items. Now, first off, I anticipate that he's going to get hammered on this on cross-examination. If you remember, no one actually measured where these pieces of evidence were in relation to one another or in relation to the curb or the flagpole, etc. So this is, of course, going to be a big issue as to whatever conclusions he draws from this information. It's the simple concept of garbage in, garbage out. But regardless, much later in the testimony, Lally sort of circled back to where these items supposedly landed and what that all means. It has to do with linear momentum and the idea that when a vehicle hits a pedestrian, the pedestrian would usually move in the direction that the vehicle was going in the first place. This is, of course, unless we're talking about the Hulk or some other similarly strong superhero. Anyway, Trooper Paul also testified that it's not uncommon for pedestrians to lose any loose items on them when they get hit. This means shoes, hats, and the like, as well as anything they're holding, for example, a glass. And he testified that when those items get tossed by a collision, they also tend to go in the same direction as the vehicle. And so this all will happen in the area of impact, which is marked more precisely at the point of impact. And so what he said was, when a pedestrian impact happens that leads to this sort of scattering of materials, there's a certain path of travel that you can track for these items. And if you follow that path, you end up at the area of impact. But again, knowing what we know about the problems with the mapping and collection of evidence at the scene, I don't see how his conclusion is going to be able to hold up on cross-examination, because Alan Jackson is going to hammer Trooper Paul hard on the fact that no one really knows with any kind of certainty where these things landed because no one tracked it to begin with. Anyway, Trooper Paul also testified that he did a number of tests as well as some data extractions from the vehicle. As for the driving tests, all of them appear to have been done basically in the Canton PD parking lot as opposed to at or nearby 34 Fairview Road. There are reasons why this can matter, such as road conditions, the curvature of the street, things like that. One of these tests in particular was a visibility analysis, and when Lally asked about the conditions that could affect it, it became clear that this test was essentially pointless, except for the fact that it pointed out that an improper assumption was made by Trooper Paul. Specifically, here's what he said.
But just in general terms, first, just describe for the jury, when you say visibility analysis, typically speaking, what are you doing in a visibility analysis?
In the visibility analysis, we are trying to see what an operator would see in their vehicle. Looking for, in this particular case, we're trying to see if the operating vehicle would be able to see a pedestrian behind the vehicle. And also in this, where we have backup cameras, we're trying to look at the cameras and see what would the cameras pick up as we would go into reverse.
And in fairness to the defendant, at this particular time when this visibility analysis was conducted, it was during the daytime, is that correct?
That's correct.
Your understanding of the crash is that it occurred at night, correct?
Correct.
Now, as far as a visibility analysis, typically, would you be looking to recreate as close as you can to the conditions at the time that the collision occurred?
In most typical cases, yes.
And why were you not able to, were you able to do that in this case?
We were not.
And why?
Due to was most, like I said, it's mostly done when we're trying to see what an operator would see a pedestrian. It's mostly done because it's an accident, but a lot of times when it's like an intentional act, visibility is not an issue in this situation. We were just want to make sure that the cameras worked and the backup sensors all worked in the vehicle.
Anyway, another thing that I found pretty interesting was the fact that when they showed the video of this visibility test, the passenger side taillight looks like it was completely broken. The light appears to not work at all. And that is totally unlike what we saw in the 5 a.m. ring footage from January 29th, 2022. So this is another thing that I wonder whether it'll be brought up on cross. One thing he said they wanted to do was an extraction of the car's infotainment module, but he said for some reason they were unable to analyze or extract that information. And when asked why, the court sustained an objection, which suggests to me that it might have to do with the federal inquiry into the case. I'm not sure. Either way, the infotainment system gives you so much detailed information, like precise timestamped GPS movements. So this would have been actually super helpful information to this case. So the fact that the prosecution doesn't have that is, in my opinion, a substantial weakness for this analysis. They also did a visual inspection and showed all the scratches and bumps on the car that we've heard about 100 times so far. They also did a mechanical inspection to see if it had any kind of defects in things like the steering and the brakes, and this showed basically no defects in the car. They also did reverse acceleration tests, reverse braking tests, and forward braking tests. And the result was they found no issues with any of the forward or reverse acceleration or braking. I'm not gonna lie, they spent a lot of time on these details, and I feel like they actually could have moved much more quickly through it to basically say, if she hit something, it's not because of any defect in the car, because it was working perfectly well. Trooper Paul also said that in this vehicle, the airbag control module is also equipped with something called an event data recorder, or an EDR. This means that they can hook up the car to some software and extract or image some information out of it and see how the driver was behaving with the vehicle. And more specifically, it records information triggered by things like sudden velocity changes. But for some reason, Trooper Paul said that the extraction they did recovered no data. And according to Trooper Paul, he said that this is common in pedestrian collision cases because in those cases, the collision doesn't actually result in changing the velocity of the car as much as, say, colliding with another vehicle. However, keep this particular detail in mind because this is inconsistent with the reasoning for another conclusion that he later made on direct exam about the data coming from another data extraction. this one being the Toyota Tech Stream extraction. Maybe he has an explanation for the inconsistency, but otherwise I'm wondering if it's going to come up on cross-examination. Okay, so anyway, let's turn to that other extraction. According to Trooper Paul, the Toyota Tech Stream is software that they can use to extract data from the car to look at the vehicle control history. This is basically the driver's driving history. One thing that's interesting is that Trooper Paul testified that they did this extraction on February 2nd, 2023, way later than the rest of these tests. He said that this was basically because it's essentially new tech and they didn't even know that it existed in the car until that particular time. Now, this being new tech could cut both ways. Either this is new and cutting edge and super reliable, or it's so new that it's maybe still in beta and can't be relied upon for reasons that we find out on cross-examination. So we'll see what comes up. But anyway, assuming that this is all accurate and reliable for now, the TechStream software looks at things that happen in the car which get logged as a result of a triggering event. Triggering events are things like sudden changes to the vehicle while the driver is operating the vehicle. Something like slamming the brakes or hitting the accelerator suddenly are going to result in triggering events. Now, this particular testimony looked at two triggering events for this vehicle, both of which apparently occurred when the SUV's total mileage was at 12,629 miles. And so they distinguished these two events by calling the first one 12629A and the second one 12629B. According to the testimony, it was reasoned and concluded that these both occurred at 34 Fairview Road. And now the chart that Trooper Paul used to explain the details in these two triggering events included information like the accelerator detail, whether it was going forward or in reverse, and the total miles per hour of the vehicle during the event. And here's what apparently happened in the 12629A event. According to this line with light blue boxes, it shows the speed slowing down for a bit, then the vehicle comes to a stop. Then the driver goes up to 6.2 miles per hour before again stopping at rest. To get to 6.2 miles per hour, she first hit the accelerator really suddenly, as you can see from these darker blue boxes, which show her going from pressing on at 0% all the way up to 50.5%. And so this sudden acceleration was actually the thing that caused the triggering event here. Then the driver again goes up to 8.7 miles per hour before the event ends. And again, to do this, she hit the accelerator pretty suddenly, pressing on the gas up to 34%. Now, at the same time, the red and yellow boxes indicate that the steering wheel was first turned to the left, then to the right, and then to the left. The vehicle also started in forward, then was put in reverse, and then traveled forward again. Now, Trooper Paul said that this looked to him like a U-turn, but this doesn't make any sense to me. With a U-turn, you're not changing the steering wheel direction from left to right, nor are you going from forward to reverse or vice versa. Rather, you're keeping it all in the same direction. Instead, this to me looks like a K-turn. And based on the prosecution's witnesses' testimony, a handful of people saw Karen Reed's SUV pull over at 34 Fairview Road with the passenger side closest to the house. And so this would mean that when she did pull over at 34 Fairview Road, the front of the car would have been facing south towards Chapman Street. And so if that's the case, it makes sense for her to have done a K-turn here to go north if that's what she decided to do. This would mean pulling forward with the steering wheel pulled to the left to pull away from the curb, then going in reverse, pulling the steering wheel to the right, and then going forward again with the steering wheel again turned to the left. This is consistent with the TechStream data from 12629A. Anyway, then Trooper Paul showed the jury 12629B. And this is where the data gets really wonky in the way that the prosecution presented it. In this one, the driver basically doesn't move the steering wheel. And if she does, it's primarily slightly to the right. But what the data looks like it says is she was driving forward and then slowly came to a stop. From the light blue boxes, you can see that at the beginning of 12629B, she starts out at 18.7 miles per hour and then comes to a stop. Then the car is put in reverse and then gets up to 24.2 miles per hour, as you can see from the light blue boxes. And according to the darker blue boxes just below that, to achieve that speed, she pressed onto the accelerator up to 74.5%. So this would indicate that she was pressing not all the way down, but 3/4 of the way down. Now, Trooper Paul then points to this chart, this 12629B, and makes a conclusion. He says that he can conclude from this data that this is consistent with a pedestrian strike. And the reason why he says that is because he says there was a sudden change of speed from 24.2 miles per hour to 23.6 miles per hour while the accelerator pedal is at a consistent 74%. Now, his reasoning does not make sense here for a number of reasons. First, going from 24.2 miles per hour to 23.6 miles per hour is not a dramatic speed change. Second, he says that she held down the accelerator consistently at 74% at the same time that the speed was going down. But if you look at the chart, that's not an accurate way of reading what this data shows. In the chart, her top acceleration force was 74.5%, and she had already let up on the accelerator right before she reached that top speed. In other words, the speed was already going down because she had already let up on the gas. And this procedure, her letting up on the gas just before reaching a top speed, is consistent across the board. She did this also each time she hit the gas during that K-turn in 12629A. At the same time, in 12629B, she never held the accelerator consistently at 74% during this event. She goes from 74.5% to 74.5% to 74% to 71.5% to 74%. So by the time she momentarily reaches that top speed, she's already let off the gas a little. And then she presses down a little more at the very end of this event. But remember, the procedure here that's been present in all of these charts that we were just shown. She hits the gas, and immediately in the next column, the speed of the car responds accordingly. The fact that this last dark blue box says she's pressed down 74% is one thing, but we don't know what her speed was in response to her pressing down on that level in that particular spot. In other words, the next column, which we don't see in this chart, could show that she went back up to 24 miles per hour as a direct result of pressing down again at 74%. So his reasoning doesn't make sense because the pattern here in this chart is the same as before, which didn't supposedly denote a pedestrian collision. Basically, what I'm saying is the pattern doesn't change, so there's nothing here suggesting that the pattern, which is the same, should lead to a different conclusion. And third, my understanding from Trooper Paul's testimony is that this data extraction records sudden changes in the car, sudden acceleration, sudden brakes, things like that. So looking at the overall chart that 12629A and 12629B appear in, I would expect there to be an entry for another triggering event, this time for her to slam on the brakes immediately following the 12629B event. But as you can see, there's nothing here. Now, the final reason that his reasoning doesn't make sense is this. Remember how earlier I said to take note of how they weren't able to extract data from the airbag control module's event data recorder. And Trooper Paul said that this was actually very common for pedestrian collisions. And the reason for that was because in specifically pedestrian collision cases, the car doesn't really have much of a change of velocity as a result of the collision. And yet his conclusion after analyzing 12629B that this was a pedestrian collision is based off of what he says is a sudden change of speed. That's velocity. So as I'm watching this testimony, I'm like, these two parts of his testimony do not fit together. If 12629B recorded an event where there was a change in speed that was sudden enough to conclude that a pedestrian was hit in that moment, how is it that the airbag control module's event data recorder didn't pick this up? If there's a reason for it, direct examination is the place to explain it. And so far, they haven't. But even aside from his reasoning here, his overall conclusion just doesn't make sense for another reason. This is because it's inconsistent with what he showed earlier from the area of impact and the evidence pieces scattered around it. And more specifically, it doesn't fit with that part and what we know from witness testimony, along with the fact that 12629A seems to show she made a K-turn at 34 Fairview Road. Let me explain. So remember how he said that the pedestrian and all the stuff that flies off of him will go in the same basic linear direction as the car. Now, he also said that John O'Keefe kind of sort of was thrown to the side because he was hit by the taillight and not the center of Karen's SUV. And first of all, I also have problems with that particular explanation because it seems that the tendency would make way more sense when the object hit was much larger than a pedestrian, like another vehicle. And I think that that other explanation also would depend heavily on where that other object was hit in relation to the center of mass of that other object. Because if an object was hit by the taillight of a car, but they hit it squarely, that's not going to cause any spin. And here, Trooper Paul said nothing about where the taillight supposedly hit John to cause this spin/sideways movement. regardless, assuming that this mapping here is correct, which obviously is an assumption because of the evidence gathering techniques.
Red Solo Cup, I fill you up.
This mapping here would suggest that the SUV hit him while it was driving north towards Cedar Crest Avenue. But then this also has to fit with the witness testimony and the data from 12629A. All of that together says that Karen was facing south towards Chapman and then made a K-turn at 34 Fairview Road, so she ended up in a forward movement while going north towards Cedar Crest. So if 12629B shows that she hit John while in reverse, this would mean that she's going in reverse southward towards Chapman. That's the opposite angle from the linear movement that all of these data pieces on this particular mapping show. That is the opposite movement from the linear projection of these various evidence pieces at the area of impact as mapped out by Trooper Paul. In other words, it's totally inconsistent with the angle at which John O'Keefe and the other pieces of evidence were supposedly scattered. So again, if this conclusion that the data from 12629B somehow shows that this was when and where Karen Reed hit John O'Keefe, it just doesn't add up. Now, if you can believe it, there were also other issues with Trooper Paul's testimony, which I expect him to get hammered on cross-examination. I already alluded to this a little bit, but this was mostly related to the fact that his conclusions about what happened to John in terms of his center of mass and how he rotated and where he landed as a result of colliding with the taillight, the basis for these conclusions felt very loosey-goosey. He basically was like, well, that's what often happens with pedestrian collisions, so that's what happened here. In other words, trust me, bro. And put simply, that's just not what we should expect from an expert witness. Not once does he reference any mathematical calculations involving John O'Keefe's height or his weight or the SUV's height or weight or its relative speed. Not once does Trooper Paul reference the height of the taillight in comparison to any of John O'Keefe's injuries. If the taillight cracked because it hit John, it would make sense that that spot on John's body where they made contact would also have a singularly serious injury. Broken bones, contusions, maybe even limbs disconnected, I don't know. But there would be some way of showing that these lined up somehow. Similarly, not once does Trooper Paul talk about how a polycarbonate piece of plastic would not only crack, but shatter when coming into contact with something as soft as a human being, even if that part of the human being has a lot of bone. Now, don't get me wrong, math is magic and science is sorcery, and I hate having to do extensive calculations for either myself. But in a case like this, we need math, we need physics to be able to make conclusions as to where the collision happened and where John landed and how he could have rotated and gotten certain injuries, etc., etc. But here, so far with this testimony, we have none of that. Now, like I said earlier, his direct examination was interrupted because they needed to do a voir dire of the witness outside the presence of the jury. So maybe Lally is disorganized enough that he'll get around to all of this mathematical calculation so that Trooper Paul can show his math skills. Or maybe we'll just get it from a different expert. But if we don't, this accident reconstruction expert has given us basically nothing to work on to conclude that Karen Reed hit John O'Keefe. Anyway, this is the world's longest recap already, but before we close out, I want to talk a little bit about that voir dire that happened. Essentially, Lally tried to ask Trooper Paul about a conclusion that he may or may not have reached about whether the taillight could have been damaged instead by hitting John O'Keefe's car at 5 a.m. at One Meadows Ave. And as it turns out, the voir dire that followed outside the presence of the jury was intended to see if this was something that he could even talk about. First of all, the voir dire revealed that the basis for any conclusion that he makes about this is, again, super loosey-goosey. No math, no mention about what's more likely to give way between metal and plastic, anything like that. So if this does end up getting in, it's going to be super, super weak testimony, and Jackson is going to tear him a new one over it, and Trooper Paul is going to be professionally embarrassed as a result. But more importantly, I don't think the jury is going to see him give an opinion on this because the witness is supposed to disclose all of the opinions that he or she intends to give by the discovery cutoff point. It's supposed to be in his expert report, which is supposed to be handed over to the defense so that they can be prepared for trial. And apparently here, none of that happened. This was literally sprung during open court with no notice to the defense at all that he was even going to go into this on direct examination. And as it turns out, the witness gave his report to the defense a long time ago. And the witness saw this ring footage like over a year ago when Court TV first published it. So even if he had already written and handed over the report before he saw this footage, if he ever intended to give an opinion about it, he had to update his report and send the updated version to the defense as soon as this decision was made. But even though he apparently saw this over a year ago, apparently the first time that he and Lally discussed Trooper Paul giving this opinion was in a final conference to discuss his pending testimony. And that meeting was 2 weeks ago. So even still, there were 2 weeks that passed where he could have updated his report and sent it to the defense. It still would have been improper to bring this in, but now it's even worse because the defense has entirely zero time to prepare for it. He's already on the stand, and the defense needs to be prepared already to cross-examine him. Anyway, the judge did not yet make a decision as to whether or not she was going to allow this in, and she said that she would have her decision either over the weekend or after the weekend. In my personal opinion, this absolutely should not come in. This does appear to be gamesmanship, and there was literally zero runtime for the defense to have any kind of notice for it. And overall, I'd say that day 25 was a mixed bag for the prosecution. But where it really matters for the prosecution's case, meaning the parts that they need to win the argument because they have the burden of proof, this was not great. Like I said, Trooper Paul's direct examination has not yet ended, and we have yet to see his cross-examination. But the fact that we haven't seen any math from an accident reconstruction expert for the prosecution yet is a huge problem for the prosecution. But those are my thoughts. What do you think? Was there anything that I missed or overlooked? Let me know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more Karen Read trial coverage, both in daily recaps and in the gavel to gavel live streaming, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. And if you really want to support the content, consider becoming a member of Byte Club. You can join either through YouTube memberships or by supporting on Patreon, and doing so means that over the long term of this channel, we can continue to devote intensive resources into trials like this one and other interesting legal topics. Otherwise, see you on day 26.